I want to get into it with a woman who has been behind the heart of not just this case, but so many cases that we care deeply about. Honestly, like Kristen Wagoner is like an angel. She's every case you care about, every issue you care about, she's defended it. She's gone to the Supreme Court with her group. She's always on the right side, like literally right, but also correct side. And we owe her a debt of gratitude. She's the CEO, president, and chief counsel of Alliance Defending Freedom, Love ADF, which represented both of the states here, Idaho and West Virginia, and submitted briefs in this case, along with 3 female athletes that do not want to have to compete against males. Kristen, thank you so much for doing this with us today. I'm so grateful to you and so proud of you because it went so well for the side of sanity today. Give me your take. I gave the audience my quick back of the envelope, but your take is more important and more informed than mine.
Well, I loved hearing your take first because I feel like we're all somewhat emotionally invested in it, but when you're sitting in it and you kind of know the ins and outs, let's just start with the court. I mean, I think overall I agree with your take. 6-3 is probably the way it will result with some concurrences as well. I think that the argument went very well. I was surprised at, well, maybe not surprised, but delighted by some of the ACLU's concessions. They essentially rolled back their arguments on Title IX altogether, even saying that the lower court decision that they won under was wrong. So that's great. I think that the veil was brought back on the fact that they refused to even define what sex is. So I'm not sure how you can find sex discrimination if you can't articulate what sex is.
That was crazy. Put a pin in that, audience, because we are definitely coming back to that issue. Yeah. Keep going.
And then, I mean, I don't know. I'm really curious to see what you think about this. And maybe it's because, like, we have been living these cases out from, we started in about 2015. First big stuff comes up 2017, where 2 boys take 15 state championships from girls. So that's how long we've been in this. And I've been with these female athletes. You've interviewed them. And we have the privilege of representing 3 that are in that case. And I wanted so badly to just stand up and scream, why are we not talking about the women here? I don't want to hear about Hecox or BPJ. I want to talk about these girls, the girls that are impacted.
Yes.
And it just, that's probably what made me most upset.
That just gave me the chills. That just gave me the chills when you said that. There were multiple times, and it did dawn on me, Kristen, that like the Supreme Court is really one of the last few places where there's true decorum that is maintained. You know, it is very formal. You are expected to behave. Every reporter had a suit on. It's not casual. Every guest that's in attendance there has got their Sunday best on. You may not stand up to stretch. You will sit there and you will obey the rules, or you will be promptly ejected. And I like that. I like that a lot. The judges come in their robes. It's all very formal. But I actually was tempted to break the protocol a couple of times to stand up and be like, what? Right? Like the nonsense when the lawyer for BPJ in the second case, this is a boy pretending to be a girl who wants the right to play in girls' sports, and said, the one thing you really shouldn't do in your ruling, because he was sensing that they were going to rule against him. And now this lawyer has switched to, let me limit my loss here so that it's just these 27 states can uphold their ban, but don't touch my 23 that affirmatively allow this. And so I think it was a Kagan, or was it Ketanji Brown Jackson, was like, tell us what not to rule. Like, tell us exactly how we're supposed to rule so that we can sort of protect these other rights. And he was like, for the love of God, don't define biological sex. What?
It's stunning, but that is their argument. I mean, we've got to look behind the curtain and know what is at issue in this. It is about biological reality, and it is about erasing the differences between men and women. And that cannot happen on our watch. It cannot happen. But, these girls that we're talking about, the opening argument of, BPJ is this 11-year-old that just wants to have fun. We should have compassion for BPJ. BPJ is obviously very confused, and we should treat BPJ with kindness. But let's be clear about this. BPJ has taken 423 girls have been affected and lost places since BPJ competed in middle school. 1,100 times this has happened, and he's taken 57 medals from the girls. So let's talk to those girls, like our client, Adalea Cross, who couldn't compete. She was in the top 3 on her team. He starts, throwing amazing supposedly after puberty blockers, when all this is not supposed to have an advantage, at least from what we heard today, and instead is displacing all these girls. And now Adelea wasn't even able to compete in the competition. She was completely knocked out because, as Justice Kavanaugh said today, there's a limited number of spots.
That's right. He was good. Kavanaugh was good today. Gorsuch was a nightmare. Kavanaugh was good. Even Chief Justice Roberts was good. We have to talk about Gorsuch in a second. But the thing on BPJ is, if you listen to just today's argument, because his lawyers were up there saying, oh, he wasn't very good. And their briefs were like, he wasn't good. He barely made the track team. And then when he got on, he wasn't at the front of the pack. And like eventually, after a lot of hard work, he moved up a little. But like you would really think this is a Charlie Brown of athletes, and none of those facts that you just said came out today in court. They left everybody there with the impression that this was like not even a middling athlete, and like, what are you complaining about? This poor guy was like this little weakling who barely made the team. But Kristen, wasn't this was the case at which I saw Riley Gaines with the shot putters who walked out of the shot put circle and said, I'm not competing against a boy. And he had started to dominate.
Megyn, there is so much to this case that, I mean, it's just, yes, it starts with our client, Adelea Cross, was on the same team as BPJ, was competing in the top of the team and had these spots. And, the first year when BPJ was in 6th grade, she was in 7th grade. And during that time, she was still in the top spot. By the next year, she starts getting knocked out. BPJ allegedly is starting to throw 10 to 20 feet longer. And then all these girls are falling off because he's taking these spots in higher competition. Next thing you know, the 5 shot put or discus people were at a different school, actually, and they protested and said, we're not competing against a boy. It's not fair to make us do that. So this is not even BPJ's team or Adelea's team. It's a completely different school protesting. And
yes,
those girls are punished by their school. Where is
for their
our
protest?
voice? Yes.
We're showing some of the girls. They got in the circle as though they were going to throw it, and then they walked out in protest, which takes so much guts. I mean, especially in this environment, it was an act of true courage for these girls to take a stand. Not mentioned at all today. And the number, like, what does the court have to go along with she pronouns for these boys? It was infuriating, Kristen, because of course it gets to the very issue of why we're all there. Reality matters. Actual fact, biological pronouns mattered. But the whole court went along with the lie today by using she, her pronouns.
Well, I wouldn't say the whole court did, but I would say some surprising justices did.
I didn't hear Alito do it. I didn't hear Thomas do it. But I definitely heard
Right.
Gorsuch do it. I think I heard Barrett do it. And I think I heard Kavanaugh do it.
It is. Language is so critical, and the court knows that. I mean, majority of the court would consider themselves to be originalists and textualists, but at the same time, this decorum that you're talking about, no one wants to hurt people. No one wants to hurt their feelings or unnecessarily offend, and I think that's how this thing, the women got steamrolled in the first place, is we don't want to have to confront and hurt people. But I think we're getting confused about what compassion and kindness actually looks like, because it can't exist without truth. And so you're right. I mean, even the idea of having to keep track of cisgender and transgender girls versus, I mean, it's mental gymnastics in the courtroom.
I find cisgender girl and cisgender woman a slur. I recoil when I hear that, and I heard it about 12 times today from Ketanji Brown Jackson, who, of course, was unable to define what a woman is during her Supreme Court confirmation hearing, and once again today seemed very focused on how to get around defining women and get around a ruling that would help women in any way, which she sensed, as I think you and I did, is coming from the majority.
Well, remember that in her nomination, when she answered that question of she couldn't answer what a woman was, she said she'd need to talk to a biologist. And fortunately, the record is chock full of them in these cases. There is ample science, real biologists that actually know what it means to be a woman and can define it. And I believe the court will uphold biological reality in these cases. But man, if today is not a reminder that we have much more work to do. And
yes.
Again, in the Idaho case, as an example, we represent 2 athletes who were beaten many times by a man at the collegiate level who took the Big Sky Championship. So, there's so many different women that have suffered as a result. And of course, we haven't even started talking about locker rooms.
I know, exactly. That's not really at issue here. So let me just play this moment where Alito called BS on BPJ's lawyer, who was trying to say, whatever you do in this opinion, do not define biological sex. Because, of course, he knew this is going to seal our fate in many cases. God forbid they just say that a woman has a certain set of gametes and a man has a different set of gametes. The women's will turn into ovaries, the man's will turn into testes, period. Or a woman can have a baby, or a woman has XX chromosome, whatever. They don't want that. And Alito was the first one to break the dam because this guy was getting away with it. Like, the last thing you should do is this. And Alito brought some sense. And then I was pleased to hear the Chief Justice tag team in, like, yeah, what Alito said. Here's that moment.
And what is that definition for equal protection purposes? What does it mean to be a boy or a girl or a man or a woman?
Sorry, I misunderstood your question. I think that the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state or the government was just understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court, and we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth sex males categorically from women's teams, and that there's a subset of those birth sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
I think here we just know that we basically know that that they've identified pursuant to their own statute, Lindsay qualifies as a birth sex male, and she's being excluded categorically from the women's teams as the statute. So we're taking the statute's definitions as we find them, and we don't dispute them.
Okay, that was in the first case, Hecox, and then it happened again in the second case with BPJ when there was a male attorney up there. We'll play that in a second.
Title IX prohibits discrimination on the basis of sex. It's a statutory term. It must mean something. You're arguing that here there's discrimination on the basis of sex. And how can we decide that question without knowing what sex means in Title IX? I mean, it could mean biological sex. It could mean gender identity. It could mean whatever a state wants to define it to mean. But it has to mean something. How can we decide that without knowing what the statutory term means?
Well, I think there are a whole range of sex-based characteristics that can give rise to discrimination. I think if someone said, I'm going to discriminate against anyone who acts in a feminine manner, like anyone with limp wrists, I don't care who they are, but I'm going to discriminate against them. Like, I think that would be sex discrimination. It would be sort of gender presentation. But I wouldn't say that's not covered by Title IX. And so I'm not saying that biological differences aren't part of sex.
You don't think we should have an operating definition of sex in Title IX? Now, I understand the idea that the question then becomes not whether or not there's discrimination on the basis of sex, but whether there's discrimination on the basis of whatever characteristic you think should be included in the definition of sex. Now, when it's used as a statutory term, I'm not sure you have that kind of flexibility. The question then would be instead, what does Congress think the word means?
But that's really what it comes down to, right, Kristen? And do you think that they will have the courage to do the very basic work of defining what biological sex means in order to determine a case in which these bans are based on biological sex?
I think it's going to be very challenging to resolve the equal protection claim without bringing some sort of definition in on sex and it being related to biological sex. I mean, under the Equal Protection Clause, the whole threshold is when the legislature draws lines, are they drawing those lines so that they're treating similarly situated people similarly? And so the biological distinctions here matter greatly, and I think that you have to define it for equal protection purposes, and we all know what it means. The only person that doesn't seem to know are progressive left activists who are actually trying to erase the rights of women and girls across this nation. Title VII also, I think you just look at the statute, which says, is there sex-based discrimination? And the statute itself anticipates that you will separate the sexes based on athletics as well as in living facilities. Because, again, they know what biological sex means and what it meant when the law was passed. So I think the court may not want to fully go there in this, but I think you almost have to resolve it. And I sure hope they do. I mean, I just kept thinking, Megyn, 10 more years of this is insanity.
No. I mean, girls are getting hurt by the day, by the second.
Well, I think of Adelaide as an example. I mean, yes, this is about sports, but we all know that, Title IX as an example has just been a weapon used by the last administration, changing the regulations, changing the standards. And as they're doing that, they're opening up locker rooms. BPJ in the locker room. Adelaide Cross, under oath, multiple times says he comes up behind her, threatens her with sexual assault. The school does nothing because they don't want to have to deal with it. And yet, all along, girls and boys are sharing these locker rooms. They have different anatomy, and that anatomy plays out in a very real way. Imagine having your daughter being threatened with sexual assault 2 to 3 times a week, which is what's going on here. No more. We got to correct it.
So the BPJ case was the case. It was the Hickox, whatever however you pronounce it, case involved somebody who was at the University of Boise, right? In Boise, Idaho.
Yes, they were in Idaho.
Boise State. Okay.
Boise State, yeah.
But this was a person who was older because they were in college and they wanted to play college sports. But the plaintiff in the other case out of West Virginia was somebody, BPJ, who said that they had started puberty blockers, like they knew that they were, quote, trans as of 3rd grade, that they went on puberty blockers straight into cross-sex hormones, and therefore never had male puberty, and therefore never developed male advantage. By the way, the plaintiff in the Idaho case, who did go through male puberty, also argued he had no advantage because he lowered his testosterone levels. And so he's just the same as you and I, as if like Shaquille O'Neal post-puberty, but taking testosterone, blockers would have no male advantage over us because it's all wiped out once his T levels go down. It's absurd, but we were operating under that premise like it was real today in the high court. But the BPJ kid was somebody who is a male, but at a very young age started to do these cross-sex hormones and so on. But you just mentioned something that doesn't come out in the coverage of BPJ, which is that there's been an allegation that he repeatedly has been saying to the girls on his teams, you can suck my D. I'm going to take my D and shove it in your pee. And like really vile, disgusting stuff, which is sexual harassment.
It absolutely is. And I mean, it's a question. When you talk to Adelaide, she's not playing sports anymore. They're in the same high school. They would be on the same team. She's been excluded from her own locker room and her own athletic team because there's one, not equal opportunity, not fair play, and he's taken a spot on the team. And then would you go back into that situation? No one would.
Oh, no. I wouldn't let my daughter do it either. I'd be afraid.
No, absolutely. And I think when we're thinking about the legal question here, the question is, can states draw legislative classifications and what's the standard that they should be based on when they're reviewed? Certainly states can recognize that generally speaking, there are advantages that biological males have that just exist. And so essentially what was being argued today is that we have to create individualized exceptions, first of all, which would mean, I don't even know how a state would pass a law if every time you needed to make an individualized exception. And then second, on the assumption that sort of the science doesn't support it. And the record's just clear that the science does. Puberty
so let's just set that up clearly for the audience. They were saying, okay, there are these laws. Title IX is allowed to discriminate on sex, and the Equal Protection Clause doesn't ban it. It's been in place for decades. It does differentiate based on sex between boys and girls, but that's been accepted. To do it in this fashion, and especially based on sports, that's been made perfectly clear is totally fine and A-OK. And so these plaintiffs couldn't get up there and say Title IX and the Equal Protection Clause have to go because they're discriminatory against our clients. They said, one of the arguments was we deserve exceptions because our clients don't have male advantage. One, because they lowered their testosterone, and one, because they did this drug regimen. And the justices were like, so we have to make an exception, like just for your clients, or like for all clients who don't have male advantage? And how are we going to figure that out, like as a group? And like the impossibility of it, Kristen, became pretty clear to me. Like, and then we got to the point where the one lawyer in BPJ's case was like, well, I think, back on the sex question, you shouldn't define biological sex in determining any of this, because even if you were to go with like the biological sex definitions that we could all recognize, there's going to be the XY chromosome kid who's got a limp wrist. He actually said that. He was talking about how like some boys have limp wrists, and like started arguing about like we should factor that stuff in figuring out who's going to get an exception and who's not.
It's completely unadministratable, but I think that also just the underlying truth of what was being debated, in just the sense that boys are treated the same under this law. Girls are treated the same under this law. And the idea that somehow boys who identify as girls need a special exception. What about the many others out there? As you said, maybe shorter. I'm short. What about those who have a disability? What about those who are just on medication and that might impact their performance? Are we doing exceptions for all of those individuals? The fact is, the ACLU today made the case that they do believe in sex-based athletics. They do believe that there are differences. They agreed to that. And they don't want to get rid of those differences. They just want boys who identify as girls to be able to come into the girls category. Mm-hmm. And we need to ensure that that doesn't happen, because women deserve equal opportunities, fairness, and privacy.
They actually got up there and tried to spin us that boys who are on puberty blockers may actually be at a disadvantage.
I heard that.
It was crazy. It was like not even puberty blockers. It was. I think this was about like a post-pubescent male who then lowers his testosterone, like the first plaintiff in Hickox. That person's at a disadvantage versus biological girls, and here's how that was spun by attorney Kathleen Hartnett, SOT 11.
I do think that's the most prudent, but definitely on a record that's more developed, because I think I think in the end of the day, it might end up being a surprise to, we don't know yet. But I think we have some good evidence that actually at the end of the day, being a transgender woman, actually to the extent there are, and you've repressed your testosterone, you're at somewhat of a disadvantage in many ways, because you have, again, this larger frame with weaker muscles and no testosterone.
Okay. By the way, it's not no testosterone. That's a lie, too. They just get their testosterone levels down to something closer to what a female would have, but they still have all the advantage of male puberty and male bone length and strength and heart and lung capacity and all the rest of it.
You mean like Will, who goes by Leah Thomas? Is that yeah. Is that what you're talking about there?
Exactly. That's a great example, because people can see it with their own eyes. Like, that's a post-pubescent male who tried to pawn himself off as female, and puberty blockers or whatever, testosterone, pills to lower it or not, you can see with your own eyes he's got an advantage over the females.
Well, the science tells us that there are denser bones, longer bones, that all of these physical advantages don't go away with puberty blockers. Again, the science confirms that even after puberty blockers, there are inherent physical advantages that boys have that girls simply don't, and they never will. And again, I think it underscores and also, I just want to say this. Why would we create an incentive for children to go on puberty blockers, particularly when the court has already just said in Skermetti that, hey, this is a medical experiment and we're, have some concerns about that, and the state should be working these things out right now. So I think there's just a lot of implications to that argument. But the science is clear, and again, so are the rights of the states to be able to draft reasonable legislative classifications that are based on sex. And really what's being done here is an argument to say, we don't really mean sex, we mean gender identity. And we know that that essentially erases women.
Yes, exactly right. And so unfortunately for us, though, we're stuck with Bostock, which was a Supreme Court case deciding that under Title VII, which governs employment, gender identity is a protected class, and you cannot refuse to hire somebody based on their gender identity, which is just really crazy. I mean, it's crazy. Just the other day, Kristen, we played a tape that a young girl at a Planet Fitness out in California took of an allegedly trans person, a guy pretending to be a girl, in the women's locker room at Planet Fitness in California. Not to get too graphic, but clearly he was pleasuring himself in the women's bathroom stall. And you could see it, not based on, you couldn't see him exactly, but you could see the shadow down below. And this clever girl took a video of the shadow, which clearly showed what he was doing. And you and I both know that the vast majority of these male to female alleged trans people are autogynephiles who are actually not gender confused. They're getting off in a sexual fantasy that in which they get turned on by dressing like women and being around women while they do it. And nonetheless, we had to be subjected to, the court talking about these people like they're, in Bostock, like they're just like you or me, or they're just like somebody who's like a black person who has an immutable characteristic that's, skin color, or a woman who's got an immutable characteristic that's, her lady parts. And they actually gave them the protection of the law, saying you have to hire these people. So if this guy who is pleasuring himself in the Planet Fitness comes into my company and he wants me to hire him, and I know that he's probably an autogynephile, I can't say no because of Bostock. Thanks, Neil Gorsuch. He wrote the opinion. And so we have to deal with that finding. But they did they excluded bathrooms and locker rooms. And now today the question is, are sports also excluded from that? And I think it's going to go the right way. But can you just give me what did you make of Gorsuch today? Because I was alarmed by him.
Well, Bostock is a decision that we've essentially been litigating around since it came out. We believe it's a wrongly decided decision and a poorly reasoned decision. And I've had Justice Gorsuch rule in some of the cases that I've argued and write the opinions, and he's done a fabulous job. But Bostock is not one of them. And I think his comments today were concerning in the sense of talking about whether we should essentially equate those who identify as the opposite sex to some sort of special class status under the law that would be akin to race. But, we don't know the reasons he was asking those questions. So it might have been that he was trying to get to a place to resolve the case in a more straightforward way. But let me say this. I mean, Justice, we've been litigating these cases for 10 years, and that issue of, whether the states must essentially protect women, we have an oral argument in that in 2 days. So, we're covering the landscape. We are continuing to work on that.
At the lower court, right? At a lower court.
Well, at the 8th Circuit Court of Appeals, so it's not too much lower. I mean, these are on their way up right now, so it won't be long.
How is that looking? Because, I was so discouraged that Gorsuch did not seem like he's going to rule in our favor on that one. Kavanaugh seemed like he wasn't going to rule in our favor on that one. And we can lose one, but we can't lose two.
I think we don't know when the issue is actually presented, and it underscores the importance of the American people. It underscores the importance of who we elect in terms of the legislators that are passing laws and the legislative history that they put in place. I would not give up on that argument. I think that there's a reason even the Department of Justice today in the argument said, we're not going to take a position on that on equal protection, and we actually believe Title IX protects girls in these instances. And when it comes to Justice Gorsuch, again, I think there are easy ways to distinguish Bostock. That was about whether in a hiring and firing situation, and you had to take account of sex in that instance, that sex was like what it turned on, whether that qualified under the statute as sex discrimination. In this context where we're truly talking about gender identity, the hinge point is not sex. A boy who identifies as a girl is treated the same as a boy who identifies as a boy. That's not sex discrimination. And states have the right to make distinctions on the basis of our biological differences. So we're going to keep going, and I think eventually we're going to win. And if we don't, I worry about Western civilization, just candidly. I mean, I think that's how important this issue is, that we can talk about what we know to be true in human biology.
Honestly, I just have to reiterate, I'm so grateful to you. It's one thing to sit in the anchor chair and get outraged at these stories, and there is a role for bringing attention to them in the media. So I'm not completely discounting the press in this, but and usually they've been a force for evil. But it takes someone like you to get off the couch, get up early, file the briefs, go through the litigations, which are just painstaking and tedious, and the interrogatories and the depositions and the motions to dismiss and the motions for summary judgment, and then the motions for appeal, and then the appellate briefs back and forth, and then the oral arguments, and then appeal up to the next level. And then it's like, it's so much work. And I know it because I used to do it for a living, and I'm so grateful to you for doing it over and over and over to make sure these things come out right. And it's on all cultural issues, but this one is the one of our time, Kristen. I can't imagine how, when you go back and you talk to the girls, like the girls in this case, what was their reaction? How are they feeling?
They're excited. They're relieved that the argument came. But I'll tell you, as we're getting ready yesterday, there's some emotion involved about being, having your face all over, and what does it mean in terms of the hate that you get, and yet they're strong and they're courageous, and I believe they've unleashed warriors by taking this battle on. MK and Maddie, they're passionate about this issue. They receive scholarships under Title IX, scholarships that if they hadn't received them, they might not have been able to go to school. And Lainey is the same. And then we've also been able to partner with Attorneys General Labrador and McCuskey in West Virginia and Idaho, and they have stood strong in this from the very beginning as we've represented the states alongside them. So there are bright lights in this, but it takes endurance and grit. And just as you said, it takes the media, it takes your voice. That's what's helping us turn this corner. It's ordinary Americans, and it's Americans who have a platform saying, we're going to stand for truth. We're contending for our girls.
These girls you just named and that we just showed, all of whom have been disadvantaged by boys pretending to be girls playing in their sports, are not going to get a puff profile done on them. They're made out to be villains. And while the attorney stood up there today, the female attorney for Hickox, and said, oh, I would never call them bigots, because there was a question, are they bigots? Oh, I would never call them that. The reality is that the trans side does call virtually every girl who comes forward to stand up for herself a bigot, a transphobe. So that's fine. You can say that to the U.S. Supreme Court. Those of us who live in the real world have heard you and the ACLU and the trans lobby do that every single day since we started fighting back. This is instead what you get. You get a profile like this from ABC News. This is on BPJ. This is just this past Monday, where I didn't hear about any of the controversy that you and I just discussed. This is how it sounded, SOT 16.
With each throw of the discus, Becky Pepper Jackson strives for perfection.
I put time in over the summer and after practices, just trying to improve my technique and get better.
The high school sophomore from Bridgeport, West Virginia, was born into a family of runners. Consistently at the back of the pack, a coach instead pushed her to learn to throw.
My times were too slow, and she didn't want me to not make the team. So she introduced me to shot put and discus, and that's when I just fell in love with it.
Becky's throws earned her a spot in the state championship last season, the first time the only known openly transgender athlete in West Virginia in any sport took a top prize.
Your teammates don't see a difference in your performance or your presence.
No, most of them are really kind. They support me all the way. It's just like being any other person on the sports team.
She may be embraced by some teammates, but she's been protested by other athletes and targeted by state lawmakers.
Targeted. It's a failed Devin Dwyer of ABC. That's what we get about Becky, who's outed herself and her identity, as opposed to what we hear about the other girls, the alleged bigots. Kristen.
Well, a number of her teammates actually had to wear their track uniforms underneath their clothes or wear their track uniforms to school because they didn't want to have to share a locker room with BPJ and a boy. A number of the teammates have been displaced. Exactly, 423 girls, again, that BPJ has competed against in the course of the last several years have lost their positions 1,100 times, and again, 57 medals. So, some of those girls are afraid to talk because of the treatment that they get, and that's all a part of the design, the bullying that goes on. But again, as this injustice occurs, as we bring light to it, more and more girls are coming forward. I'm sure you saw a recent UN report says there have been upwards of 900 medals lost.
Yes, I was glad that came out today. I was very glad that came out today because the one lawyer got up there and was like, Oh, this is BPJ's lawyer. And the lawyer was like, oh, there were no cuts. So BPJ didn't cost anybody their place on the team. And he wasn't very good. So he didn't cost anybody, any medals or scholarships. And I think it was in rebuttal, but one of the other lawyers got up there and said, let me give you the stats. Like the UN just came out with this report. It was like 900 girls lost, or 600 girls lost 900 medals to boys playing. This is a lie. They continue to tell it. John Oliver told this lie on his show. My daughter's history teacher last year told this lie to her and her friend, saying, it's not happening, Kristen. There just really aren't boys playing in girls' sports taking their medals.
Well, a significant portion of our work has been dealing with how gender ideology is affecting all Americans and, frankly, all around the world. The UN report, as an example, was a central feature of a hearing that we testified at, along with the author of that report. And Sharon Davies, an example. This is happening around the world where they are losing these medals. In addition, when we talk about the work that Alliance Defending Freedom's had to do in these areas, lies can't exist without censorship taking place. And so we have to ensure that we can continue to speak freely and have the right to raise our kids consistent with the belief that men and women are different and to celebrate that. And that's the underlying issue here and what's really going on. The last thing I want to make sure is clear. It's not about not having a team to play on. It's that athletics, biological differences matter. And so the biological boys need to play in their category. And the girls play in theirs, or they can play co-ed, or actually the girls, even who identify as boys, can play in the boys category because the laws recognize these biological distinctions and say, no, the girls don't have an unfair advantage. So again, I think that the issues get distorted in the press and how they're recounted, but I am optimistic that the court's going to rule the right way. I am also resolved that we have a lot more work to do before we ensure that the next generation doesn't have to deal with this ideology that crushes people and families.
Yes, we will cover the Eighth Circuit argument that you have coming up in 2 days. I will see you tonight. And again, my profound thanks to you and Alliance Defending Freedom.
We're looking forward to celebrating tonight, so thanks for joining us at it.
I can't wait.